Hello and welcome to this Stride workshop, which is part of Positive East Staying In Together programme. Today's presentation is LGBTQI Living Together. If you're married or in a civil partnership or cohabiting, then this might be of interest to you. At this Stride workshop today, Simon Farris from Positive East's Information and Advice team will be talking about what benefits are affected if you live together, social housing tenancies and succession rules if your partner dies, and registering a civil partnership. Simon, it's great to have you with us.
Hi, Greg. Good to see you too.
Shall we crack on with the presentation? Because we're really looking forward to what you've got to tell us today.
Sure. Okay. So I'm going to share my screen with you all now. So let me kick off by doing that. Some of you may already know me, but for those who don't, I joined Positive East in 2001 and work in the Information and Advice Service team. My colleagues and I advise service users what benefits they might be entitled to, complete forms, request supporting medical evidence, and challenge any decisions that are thought to be incorrect. Some of the other things that we do include to advise people what their housing options are, what to do when disrepairs are not dealt with by landlords, as well as applying for grants to help with things such as daily living costs, household furnishings, and to help reduce utility bill debts. Before the COVID outbreak, I would meet with service users at HIV treatment centres at the Royal London Hospital, Newham Hospital, and the Solid Goodman Centre in Stratford. But like many organisations over the past year, we've still been able to continue to deliver services. And this we do by telephone, video call, and online. For today's workshop, we will have a look at the following. What benefits are affected if you live together, social housing tenancies and succession rules, formalising a relationship, and the importance of making a will. So to start off with, let's talk about money. And I thought we'd start by looking at benefits. The main thing to remember when we talk about benefits is that all benefits are either means tested or non-means tested. If you are married in a civil partnership or cohabitating, and either of you receive any of the non-means tested benefits listed here on the right side column, then the good news is that regardless of whatever your household income may be, or how much savings you have, you will continue to be entitled to the same amount. But should either of you receive any of the benefits listed here on the left side column, the means tested benefits, then how much you are entitled to is likely to be affected by what your household income is, such as money from work, or if you have combined savings of more than £6,000. Now, the benefit system can be very confusing, and often people don't know if they are in receipt of income related or contribution based benefits. And here, as you can see, I've listed them as non-means tested benefits as well as means tested benefits. But if you're not sure, either contact whoever pays you the benefit and ask them, or alternatively, you can get advice by phoning the Positive East advice line or your local Citizens Advice Bureau. Now, if there are any changes of circumstances, such as living together, doing paid work, or if you inherit any money, it's important that you notify whoever pays you the benefit that you are entitled that you're receiving. That is, if you're receiving one of the means tested benefits. That way, your entitlement can be reassessed, and this will avoid the risk of you being overpaid. If you're overpaid benefit, it can be recovered. If you want to check what benefits you are entitled to and how much, you can do so online. There are benefit calculators, and there's a good one that's available at the Turn to Us website. Just Google search Turn to Us, and you'll find it quite easily. Or alternatively, you can again phone the Positive East advice line or get in contact get in contact rather with your local Citizens Advice Bureau. Now, in terms of banking, if you're living together and you and your partner have separate bank accounts, it's worth noting that neither of you can have access to money held in the other partner's account. If one partner dies, any balance in that account will be this property of your partner's estate and cannot be used until the estate is settled. However, if you have a joint account, then both you and your partner have access to the account, regardless of whether only one of you pays into it. If your relationship ends and you can't agree who the money belongs to, a court might have to decide. If the account is in joint names, on the death of one partner, the other partner becomes entitled to the balance and can continue to have unlimited access to the account. However, a proportion of the balance will be taken into account when calculating the value of the estate of the person who has died. And in terms of debts, well, this is a bit of a mixed bag. First, you are only liable for any debts which are in your name only, and not for any debts which are just in your partner's name. But you may be responsible for the whole amount of any debts that are in joint names, and for other debts for which you have joint legal responsibility, such as council tax, in which case you and your partner are responsible for that debt, regardless of whether one of you contributes or not. If your partner has a debt and you acted as guarantor, then you will be held legally responsible for paying it. But some good news, if you're married, you won't be responsible for any financial obligations or debts that your partner had before you were married. Okay, before we look at who can inherit a council or housing association tenancy, I want to apologise as there's going to be a repetitive use of the word tenancy. So, to kick off, there are some key things to be aware of. When your partner or relative moves in with you, you might want to consider contacting the council or your housing association to let them know. And you might have to put this in writing. This will then act as proof of how long it has also been their home. If you're married or in a civil partnership, it's fairly straightforward if you want your partner to be included on your tenancy agreement. Again, just contact the council or your housing association and they will tell you what the procedure is for converting your existing tenancy agreement to a joint tenancy agreement. As for taking over a tenancy in the event of the death of the tenant, there's a few things to be aware of. The first is that partners and relatives have different rights when it comes to inheriting a tenancy, which is known as succession, tongue twister. And the rules about inheriting a council or housing association tenancy are similar. The second thing is that your right to inherit a tenancy will depend on your relationship with the tenant, what type of tenancy they had, and when the tenancy started. The third thing is that the council or housing association will ask you to provide evidence about who you are, what was your relationship with the tenant who died, and how long you had lived with them. And finally, the fourth thing is that the council can take action to evict you from the property if you don't have a right to inherit tenancy and continue to live in the property after the death of the tenant. So let's look at who exactly can inherit or succeed a tenancy. If you're a joint council or housing association tenant, then you will automatically become the sole tenant if the other joint tenant dies. However, not all couples will be joint tenants, but provided that you were married, then you will be able to inherit the tenancy. That is, provided that the tenant who died was your husband, wife, or civil partner, and it was your home at the time they died. If you were cohabitating with the tenant, the key thing to be aware of is that if the tenancy started after the 1st of April 2012, then you can inherit the tenancy as long as it was your home when your cohabitee died. But if the tenancy started before the 1st of April 2012, you can only inherit the tenancy provided that it was your home at the time your cohabitee died and you were living together for at least 12 months before they died. The succession rights of relatives will depend upon when the tenancy started. So if the tenancy started after the 1st of April 2012, you can only inherit a relative's tenancy if the tenancy agreement says this is allowed. But if the tenancy started before the 1st of April 2012, you can inherit a relative's tenancy provided that A, the tenancy was your home when the tenant died, B, the tenant did not have a spouse or civil partner who can inherit the tenancy, and C, you were living with the tenant for at least 12 months before they died. If you're unsure about anything, please don't hesitate to get independent advice, either from the Positive East Advice Line, your local citizens advice, or your local community law centre. Now, I recently received the following questions. So the first question was, do I need a solicitor to add a spouse or partner to the property deeds? Now, this is a question about home ownership. So the answer is that adding a partner to the deeds of a property while still retaining a share yourself is known as a transfer of equity. Many people choose to share the ownership of their home after getting married or entering into a civil partnership. You can do it yourself, as a transfer of equity can be a relatively simple process, which does not necessarily require any assistance from a solicitor. However, the process can get quite complicated. The process can be complicated. So most people complete the process through a conveyancing solicitor. Another question was, if I own my property and my partner wants to move in with me, will he have to give up his council or housing association property? And surprisingly, the answer is no. The tenancy does not need to be given up, but it's important to remember is that the property cannot be sublet without the landlord's permission, and the tenant is liable to continue to pay the rent. But I would suggest that you check your tenancy agreement for any clauses about leaving the property unoccupied, because if you do, and there is such a clause, then the landlords can start repossession proceedings against you. And the third question here is, we are both named on the tenancy agreement, but who gets to stay in the property if we decide to separate? Well, this is not an easy question to answer because there's quite a few factors to take into consideration. But to avoid being deemed as intentionally making yourself homeless before leaving the property, seek advice either, again, Positive East Advice Line, your local Citizens Advice Bureau, or your local community law centre. Okay, so moving on to the next slide, let's have a look at something that's a bit more uplifting, and that is formalising a relationship. And congratulations to anyone who's watching this and thinking of tying the knot. May you both have many years of happiness together. Okay, a bit of background history first. So since the Civil Partnership Act 2004, same-sex couples have been able to formalise their relationships, which has afforded couples many of the same rights as heterosexual couples. Since 2018, heterosexual couples have also been allowed to form a civil partnership. Full equality came into effect by the passing of the Same-Sex Couples Act in 2013 in England and Wales. Scotland followed in 2014, and recently in 2020, so did Northern Ireland. If you have a civil partnership, you can convert it into a marriage, with the exception in Scotland where you will need first to dissolve the mutual civil partnership. Whether you are thinking of having a civil partnership or getting married, it's worth noting that there are similarities in what you're going to need to do. If you want to register a civil partnership, the first thing you will need to do is to give notice of your intention to register. And you can do this by contacting the local registry office where you live. This is regardless of where you actually intend to later register your civil partnership. The notice will then be made available in the registry office for people, for people to see. And this will be in the area in which both of you live and the area where you're going to later register your civil partnership. That is, if it's different. This is to give an opportunity for any objections to be made. So I guess it's time for you to make peace with any foes you may have. You will need to provide details of the date and place where your civil partnership is going to be registered. So, think ahead and contact the venue. After 28 days, you can then have your ceremony. Having a ceremony, though, is not actually a requirement for civil partnership purposes. Afterwards, you will need to register your civil partnership by signing what is called a legal document, which is known as the Civil Partnership Schedule. If your ceremony is in a registry office, they will take care of this for you. As an aside, religious premises are not obliged to host civil partnership ceremonies, but if they do, they can choose to either host all civil partnerships, just civil partnerships between two people of the same sex, or just civil partnerships between two people of the opposite sex. So it's good to see a little bit of discrimination is still in the system. As mentioned before, since the passing of the Same-Sex Couples Act, same-sex couples can now marry in a civil ceremony. You can even have a religious ceremony provided that the religious organisation approves to marry same-sex couples. If you're transgendered and don't have a gender recognition certificate, then you will be considered the gender on your original birth certificate. Giving notice of marriage is the same process as registering a civil partnership. You can get married at a registry office, church, or official venue, and afterwards you will need to sign the marriage register in front of witnesses. If you're having a Church of England ceremony, then the church itself can register your marriage at the same time as performing a religious ceremony. The difference is, though, that the banns need to be read in church on 3 Sundays before the ceremony. On a final note, you might want to consider having a prenuptial or postnuptial agreement. Such agreements outline how your assets are to be divided in the event of a divorce. And to finish off today's presentation, a quick look at the importance of making a will. If you are married or in a civil partnership, should your partner die, then you will inherit whatever provisions have been made to you. But if either married partner dies without making a will, the surviving partner will inherit all or some of the estate, depending on how much it's worth. If you were not married or in a civil partnership, if one partner dies without leaving a will, the surviving partner will not automatically inherit anything unless the couple owned property jointly. So the rule of thumb is that as an unmarried couple, you need to make a will if you wish to ensure that your partner inherits your estate. Otherwise, the rules of intestacy will apply. And that's quite a complicated thing to explain. Again, if you're affected by this, I strongly suggest that you seek further advice. In terms of making a will, it's quite an easy process, and there are different ways of doing so. For example, you could ask a solicitor. Some unions have a free of charge service, and you can have a look online. There's quite a lot of guidance online, and perhaps you might even want to do one yourself. So that brings us to the end. I hope some of it's been helpful for some of you. And as always, as I've been saying throughout, if there's anything you're not sure about, please, don't hesitate to come, to get in contact with us and here at Positive East, or contact your local Citizens Advice Bureau or your local law centre for further advice.